Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia Angelini.
And I'm Sydney Osmar.
Welcome to Hull on Estates. You're listening to episode number 672. Today we're going to be discussing some interesting cases dealing with, the new legislation that allows imperfect wills to be saved.
Yes, it's, as Natalia mentioned, new legislation. So as nerdy lawyers, we're always excited when new case law comes down the pipeline and we get a little more clarity on how it's going to impact things and how it's interpreted and how we can use it as practitioners. So we've come across two cases that we wanted to share. The first one, just to start with some background, Ontario was historically a strict compliance regime. So when it comes to the validity of wills, we have our Section 4 under the Succession Law Reform Act, which sets out the formalities of execution. Here it sets out, you need to have the testator sign or direct someone in their presence to sign the will at its end. It has to be in the presence of two witnesses who also need to attest the will, and a couple other requirements. Now, formally, if you were offside on those, the will would just be invalid. And we now have our new legislation under Section 21.1.
Right, which is a real game changer, because before this time, we've had cases that are where people we've either been on the receiving end or the, on the applicant's end dealing with this kind of issue, and there's no success. But the whole playing field has changed now. So we're already starting to see a bunch of cases that are coming before the court, and it's really interesting how things are progressing.
Yeah,
that's good. Yeah.
Okay, so the first one we wanted to look at today, and I apologize, I'm probably going to mispronounce. Voiska and Ostrovsky. I'll give the citation. It's probably easier to look up that way. 2023 ONSC 3894, and it came before Justice Myers. So this decision, we have a mother's estate. The only beneficiaries are her two children. She dies in September of 2022. And back in October of 2011, she and her husband went to the lawyers. They signed new wills and new powers of attorney. At the meeting, there was a flurry of documents going back and forth. 6 documents in total were exchanged and signed. And in all of that happening, unfortunately, the mother's will, the lawyer forgot to sign or missed it. So as a result of human error only, this document wasn't fully signed properly under the legislation. The lawyer, he stored it in his safe, and there were other things that the court looked to say, this was obviously intended to be a valid will. Everyone proceeded on that basis. The deceased herself had thought it was properly executed. And it wasn't until she passed away that everyone looked at the will and realized the mistake. So it came before the court, and the Justice Myers, he looked to Section 21.1, which sets out that the court may, on an application, order that a document or writing is effective as the last will of the deceased, as though it had been properly executed, if it's clear that it sets out the testamentary intentions of the deceased.
Right. And also, this is going to apply if this person died after January 1st, 2022, right? Which is how the date the legislation takes effect. And so that fits into our facts.
Yes. So in this case, she died in September of 2022, so she falls within. And in this decision, Justice Myers actually went on to say that he couldn't see a more textbook example of what the cases this legislation was intended for. It sort of checked off all of the boxes. And in his Honor's decision, he looked to a couple other decisions that have recently come through under. One was Cruz and Public Guardian and Trustee, and the citation on that decision is 2023 ONSC 3629. And actually, our partner, David Smith, was a counsel on this decision. So he probably has a lot more to say about it. But this is another example where the formalities were not met. There was a will that was signed but unwitnessed. It was in an envelope with a note to the estate trustee asking the estate trustee to get it witnessed. So it was clear in this case that the deceased, it was their final intentions. They just had a misunderstanding of what witnessing actually meant. And they were able to use the legislation to get it validated.
Yeah, and I mean, this is really, I'm a little bit amazed by this kind of outcome, because to have zero witnesses and to be able to save the day, it's such a departure from how things were before, right? And I do think it is important for everyone to appreciate this. By no means should be taken as the court kind of treating these scenarios lightly, right? The court is looking at the intention of the deceased and looking at the circumstances and rendering its decision. So I'm hoping, as exciting as all of these new cases are, I'm hoping it doesn't trigger, a mass kind of waterfall, I guess, of cases where they're not really, legitimate scenarios.
Well, and that's an interesting point. And it brings me to the next decision we wanted to look at today, which was just released by the court on July 24th. And it has some helpful commentary on some of the limitations of the application of Section 21.1 and provides an example where the court found, the will was actually still validated, but under a different provision of the Succession Law Reform Act. And the court found that it just wasn't an appropriate application of Section 21.1. So this decision is the estate of Harold Franklin Campbell, 2023 ONSC 4315. And in this one, the deceased had a will, which was done after his first wife had died in March of 1996. At some point after that, in 2000, I believe, he remarries, and under the operation of former Section 16 of the Succession Law Reform Act, the will was revoked. Now, we know now that provision has since been repealed, but back then it was not, so the will was revoked. The deceased didn't know about this. He himself thought the will still remained valid, and he prepared two handwritten notes and stapled them to the will. And so the question was whether the handwritten notes actually revived the will or not. And the applicant was asking the court to go under Section 21.1 to find that the deceased had intended to rely on the will, and that under this section, the holographs were valid as revivals. And it was a 4-part process that the applicant was asking the court to look at. And the court said, you know what, we don't even need to do this. We have Section 19, which allows us to say if you can have a revival. The court found that the notes were valid codicils. And so under Section 19, they revived the wills. We don't need to look to Section 21. And they specifically provided that, Section 21.1 does not provide the court with a license to read into testamentary documents intentions that aren't already set out in them or that can't be clearly inferred from admissible extrinsic evidence.
Right. It's such an important point, right? And so I guess it's also a reminder to all of us as lawyers, don't just race to the court, flailing Section 21 in your hand. There's other sections that may be simpler and, just on point to pursue, like in this case, Section 19, where the codicils act to revive the original will.
That's right. There might be a more direct route or a route that's had a little bit more history and a little bit more jurisprudence out there for you to go to for guidance.
Right. And, we've also still got situations where we've got the avenues of rectification or interpretation. So every scenario, I suppose, is different. But it is, I feel heartened that we've got some cases that are, some of them that really are the perfect examples of how Section 21 should be used. And they're saving testamentary instruments that otherwise would be void, and it would create such a problem for the estate and the administration. So it is so nice to see that this mechanism is out there for the courts to apply and to help out the executors and surviving heirs.
Yeah, it's definitely that's a good point. And even in the first decision we spoke about, in that case, all of the parties were on board. No one was fighting it. Like they wanted the will to be found to be validated. And there was one party who actually even was slightly financially prejudiced by the if it were to be validated, they got a slightly lesser entitlement, but they still were like, hey, we know this was the last wishes. We want to respect that. I don't know how much of a impact that has on the court when they're looking at it, but it's definitely helpful when everyone's like, hey, we all know this is what they wanted.
Right.
One small minor thing was not minor, but one thing was missed. Everything else was in place. And
Right.
it's a little bit easier for the court to look at the provision and say, you know what, this is exactly what this was intended to do. And it prevents us having an intestacy or, other potential consequences.
Right. Because let's say there is an intestacy because there's no prior will, and maybe there's trouble finding that beneficiaries, like completing that family tree, and right, it can add a slew of costs and time and effort. So,
Yeah,
but we'll keep monitoring.
definitely. It's interesting to see. And I mean, there seems to be a lot of cases coming out. So we'll keep everyone updated on it.
Yeah, we sure do. We sure will. So I think that concludes our podcast. Until next time, we want to thank you for listening. I'm Natalia Angelini.
And I'm Sydney Osmar.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page on our website.
Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hollandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.